friends. Hey, friends. Hey, Kel. Thank you, ma'am. Hit that thumbs up button to show your support. I appreciate that. Thank you so much. Hey, Spinsies. Good morning. If you're new, welcome. Please leave your DNA all over that like button while you're at it. Do all the other YouTubey things. Hashtag replay if you're watching it later. Hey, Ro. Good to see you. G'day. I try to say it the way the Aussies say it because it's not good day. They don't, I mean, they mean good day, but they don't say good day. They say g'day, g'day. It's like gid, g'day, g'day. I also know that it's not pronounced Melbourne, although I say it that way. It's Melbourne. But, you know, Aussies are bad about not using the R's in a lot of their words, except till they say the word no, and then it's like nor. I'm throwing a little shade your way, Rogue. G'day, mate. G'day. All right. So we are multi-streaming again today. We have Sarah Boone, which will be on the stand soon. And then also we are streaming on the same channel, the Ferris trial. So how do you think I feel living in Australia and talking like an American? Okay, well, there you go. There you go. All right. So this morning on the stand was the female Chelsea, I forget her last name, the female interviewer, interrogator that was, you know. So she's being cross-examined, and then the state rests. So, never seen a more pathetic cross-examination of a credible witness. Okay, so for the for completeness, I'm going to go ahead and play that, but we're going to 1.25 it, get through it really quick. Then we can skip through the break that they have right before Sarah Boone takes the stand. Here we go. I'm going to put this, like I said, on 1.25. Hey, Renee. Oh, thank you so much.
Ma'am, good morning.
They
Again,
are.
Can you state and spell your name for the record?
They are feeling better. The littlest one, she did not want to miss school today, so she went to school, and yeah. Yeah, thanks for asking, and I hope that yours feeling better too. I know you said that your son has COVID, or that your kiddo has COVID. I don't know if it's a little boy or a little girl, but ugh. Rogue says these defense attorneys are clinging to that BS story Sarah told about being tricked to go for the interview. Yeah. I knew that's what they were going to do to her. All right, let's get through this.
My name is Chelsea Kupsel, Chelsey, Koepsel.
Absolutely, Renee, yes.
We intended to witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Good morning, ma'am.
Good morning.
God love him. I'm sorry, Renee.
Now, it's my understanding that on February 24th, 2020, you responded to this crime scene. Is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers.
It is.
there
It's
prior to
pretty.
you arriving, is that correct?
She's a beautiful
Yes.
Were
woman.
you the first detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who is your partner? Down
Detective Scott Lowen?
there? Throughout the whole time, you and Detective Lowen worked on this case together. Is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including like deputy sheriffs, like in uniform?
Yes, ma'am.
Yes, approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they have.
All right, so that had already been done by the time that you arrived, is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your,
She's
or what
actually
you're
the
trying to accomplish in the investigation is basically
investigator
the
for the-
what took place. Would you agree with me there?
sheriff's
Yes, sir.
department that worked
And you
on
can do that one or two ways, or a combination.
this
of ways.
case.
One is to take testimony of potential witnesses, is that correct?
Yes, it is.
All right. This day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone, is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it, is that correct?
Yes, we have.
And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what, you had a chance to talk to him, he told you his involvement, is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and something goes on for a long time, you can refer back to it, is that correct?
Yes.
Okay. All right, so, and out there, that's part of talking to witnesses or potential witnesses. Okay, also, it's your job too to identify potential physical evidence in a case.
Yes, it is.
All right, and in fact, on the 24th, did you do that?
Yes, I did.
Okay. Did you have anyone assisting you in doing that aspect of it?
Yes, crime scene investigators and digital forensics investigator.
All right, and was Miss Melissa Roffengarden, that's how it's pronounced? Pronounce it for me.
Rough Garden.
Rothgarden, okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay. So were y'all walking around together? Give the jury an idea of how that process takes place, please.
So yes, when I initially arrived on scene, I introduced myself to Sarah Boone and explained that I wished to go inside her residence, which she gave me consent to go in and look around. I went in, looked around, and then when my CSIs arrived, they would go in, take pictures,
You guys are cracking me
and then
up.
I kind of leave them to do what they need to do as far as taking pictures and documenting things and measurements. And then that's when I conducted my interviews. And then I would meet back up with my crime scene investigator after interviews were conducted to kind of follow up with like things that I was told that would help us like identify things from the scene.
Oh, thank you, Renee. I love when people feel
And
like
so,
that.
I mean, there's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process during that day. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct, or pictures, or actually collect and take away. Is that correct?
Yes, that's accurate.
All right. In that case, the suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you view the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected?
Hey,
and
Miss King,
what
good
would not be
morning.
collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination for me to give the final yes or no.
Do you recall which items you decided to collect from the suitcase?
Do you have the property form that I can refer to?
No, I'll try to find it.
I know some of them, but
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
Yes, to my understanding and to my recollection, we collected things that had blood left over on it. I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one, I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically, but that is what I recall.
Correct, and I understand, and that's fair. Okay. So potentially you collect these items because you believe they're evidence for the case potentially, is that correct?
Yes,
And some of these items you actually collect with the potential that you might need to have them examined in greater detail, is that correct?
yes,
An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that, is that correct?
yes.
And also the stuff that you're learning outside of these items also helps you in making that determination, isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
All right. So out of the items that were collected at the house or the apartment, at those items, was anything, to your knowledge, sent off for further examination?
I believe so, but if it was, there would be, they would be sent to the Florida Department of Law Enforcement for further testing.
Okay. And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay. Now, are you aware at one point in time, there were some fingernail clippings or fingernail swabs taken from Ms. Sarah Boone? Is that correct?
Yes.
In fact, that was done on her interview date, on the, would it have been the 25th?
Yes, sir.
Is that correct?
Yes.
Okay, and that's what we witnessed in the video?
Yes.
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
Yes.
And those, there would have been some fingertip swabs of Jorge Torres. Were you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the ones from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA?
Oh, okay. Yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay. Who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it from, or I would request it to the crime scene investigator, and she would author the, I guess, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLE for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
Are you aware of the results from those evaluations? I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question about it, okay? But basically, you're aware that it was done, the procedure was done?
Yes.
The analysis was done. Okay. Now, ma'am, so you're through the first day, then we get to the second day, which would have been, I believe, the 25th of February, is that correct?
Yes.
And on the 25th of February, was Mr. Torres' autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
Okay. And did you communicate with the medical examiner at that time?
Yes, I did.
During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Now, initially, when you were on the scene on the 24th, did you view Mr. Torres's body?
Yes, I did.
Did you notice in and of yourself on your own something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him, yes.
Okay, so after the autopsy, you had additional information, is that correct?
Yes, I did.
Now, there was an interview, well, I don't know if it was an interview, there was a meeting set up for Sarah Boone, is that correct?
Yes.
On the 25th? Is
Yeah.
that correct?
Yes.
Can you tell me how that meeting was arranged or how that meeting was set up, please?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification, and I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy, and then obviously from watching the video towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene because I obviously would have, said my goodbyes and told her, hey, we're leaving. We're going to make next of kin notification. She was very concerned about that. So I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
Okay. All right. The day prior to that, on the 24th, ma'am, you received Sarah Boone's phone, is that correct?
Yes, her phone was on the scene, yes.
Ms. King, Ms. King, they have,
Sarah Boone had given you.
they shared some cell phone data information
No, she was not
yesterday,
allowed in the apartment to give me the phone.
but I'm not sure if it was,
Yes.
very in-depth. It was
Yes,
just
I was
some
given
of
permission
the
to go through her phone, yes.
text
So at that
messages
time,
that
you
she'd
hadn't
sent the
applied for any type of search warrant
George's
to get or search the phone. Is that
family or something.
No, it was based off of consent.
correct? Okay. So she had consented to you for you to have her phone. Is
Yes.
that correct? She also provided.
Aw,
you
Rogue,
code
if you're still
to get
here,
it.
I hope you have a good night's
Yes.
sleep tonight.
So at this point in time, Ms. Boone is cooperating with you, isn't that correct?
Yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out or consent to go through her phone. There was evidence on her phone that I needed to be downloaded. And at the time, I was willing to give back her phone before going through it. And then once we had gone through it and those videos were found, I felt like this was very different. And it changed my perspective on consent. And I decided at that time that it was best to write a search warrant. So consent couldn't be basically like I knew I was going to take her phone. So consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, maybe we didn't get a full download. I may have said something along the lines of that. As far as me taking the phone, and then I wrote a search warrant. I either started writing the search warrant the night of, but it wasn't signed I didn't submit it until the next day. And then it was signed the next day on the 25th.
So basically, what you're telling us is that she could have withdrawn her consent at any time prior to that search warrant being received. Is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone, so I knew I could get a search warrant to go through the phone based off there being evidence. Like the 911 calls, and her explaining to me that they had spoken to family members.
Please silence your cell phones.
since they had explained to me that they spoke with family members the night prior. So I wanted to obviously corroborate
Uh-oh.
her statement. So I knew that I would be able to get into the phone for a
Judge
search
Cranick's
warrant.
gonna pull out the hammer.
But yeah, she could have not consented, and she could have not signed the paper consenting while we were on scene.
But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you the next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
So, did you reach out to Ms. Boone that next day, or did Ms. Boone reach out to you?
I don't recall a specific, if she reached out to me the night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
On the 25th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day, or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then. But she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her to set up this meeting with her. Is that correct?
It's one or the other.
One or the other?
Yes.
Okay. As it to it being one or the other, you did you prepared the investigative report in this case, is that correct?
Yes, I did.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes,
Is that correct?
it was a summary, yes.
All right, as far as evidence, as far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning to, not to the end, but to the point where the report stops. And it seems like in your investigative report, you are very thorough about details. Is that correct?
I was a detailed person. Yes, thank you.
Okay. So being the detailed person you are, and absolutely.
She thanked him.
doing
She's
your
like,
law
"Thank you.
enforcement
I am
training,
detailed."
They tell you, and they
I take
tell
that
you
as a
your
compliment.
report should be very much in detail. Is that correct?
Yes.
Okay? Because you might have to refer back to them at a later time. Is that one of the reasons? Is that correct?
Yes, I'm to prepare myself for depositions and trials.
Okay, and just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made with Sarah Boone to meet you down, and where did y'all meet?
The Orange County Sheriff's Office Central Operations.
All right, to meet you at the Orange County Sheriff's Office. I did not see that in the report. Do you have an explanation why?
It's not typically something I would put in my report.
Okay. Do you remember in having the conversation with Ms. Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good? You remember telling her that?
That never happened.
Okay. Ma'am? Judge, if I could have a moment.
Yes, sir, of course.
Ma'am, during this time frame, were you pregnant at that time?
Yes, I was.
Okay. All right. Well, anyway, Ms. Boone, there was a meeting arranged. Is that correct?
For the 25th at 3 p.m., yes.
Yes, and Ms. Boone showed up for that meeting.
She did.
25th.
Yes.
We saw it. Okay. Now, ma'am, I'd like to talk to you about some other investigation. On witnesses, other witnesses that you took their testimony or statements, recorded statements at different times. Okay? Do you remember Abraham Marino?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Marino's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay. Ma'am, as to who was with you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
So what's the issue here? I don't understand what he's trying to get at.
Ma'am, do you have an independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview. Yes, I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, did that interview, what date did that interview take place on?
I believe the 26th, February 26th of 2020.
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
Ma'am, are you familiar with a witness by the name of Brandon Moats?
Yes, I am.
On February the 27th of 2020, did you take, interview Brandon Moats?
I believe so. It was either the 26th or 27th, yes.
If you were to see your investigative report, would that help refresh your memory?
Your Honor, I would again object. She hasn't indicated that she needs assistance with her memory.
Approach. Objection sustained.
Ma'am, if it was the 27th, you would not disagree with that, would you?
Well, I just stated that it was either the 26th or 27th.
Okay, thank you. Ma'am, Mr. Moats, he was the neighbor living in the apartment, or the connecting apartment, wall apartment, with Ms. Boone and Mr. Torres, is that correct?
Yes.
And he's the one who told you about the loud noise, is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent, do you know his last name?
I would butcher it.
Me too, but Taglow, something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah, the 26th or 27th would be my memory.
Okay, thank you. And then, did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation, and yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Now, let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down. And, ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay. Did you tell Ms. Boone in arranging the meeting that when she came down there, she was going to be arrested?
Your Honor, I'm going to object this to relevance.
Approach.
Oh, Lord, have mercy. Lord, have mercy.
So, ma'am, at that time, you did not tell Ms. Boone, prior to coming down there, that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Ms. Boone that she was going to be arrested?
We plan to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee, not come, and then we have to go find her and make it more difficult for everyone.
Or potentially get an attorney to come with her?
She was read her rights that said that she has a right to an attorney, and if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there. Is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't in contact with her, physical contact with her.
Okay. So, but you said potentially for fleeing. My question was, potentially she could have got an attorney too to come with her. Is that not correct?
I misunderstood your question. I didn't hear potentially bring an attorney with her, but yes, I guess she potentially brought an attorney with her.
So Ms. Boone shows up, and you tell her that some things that we need to talk about. Is that correct?
Specific verbiage, I know I said something along the lines of, obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
And prior to discussing it with her and asking her questions, you did read her Miranda warnings. Is that correct?
Prior to, I'm sorry, one more time?
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings. Is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay. Ma'am, do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so? Do you independently remember reading Ms. Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but I don't recall that that's what that says. But it is on audio and video recording.
Okay, thank you.
You're welcome.
Now, ma'am. at
All
that
right,
point in
P.
time,
Lola. Hey, dearie. Hey, dear. We'll be getting there soon. I just did not want
Ms.
to
Boone wasn't under arrest.
jump
Is that
ship
correct?
straight to that.
Ms. Boone was not going to be free to leave once
You
she
know,
was
like
in
I
my
said
custody.
earlier, for the sake of
At that
completeness,
point in
I
time,
wanted to
had you told Ms.
get
Boone
through
that she
this
was not free to leave?
cross-examination.
No, I did not.
At that point in time, had you told Ms. Boone that she was under arrest?
I told her at the end of the interview.
Okay, before the interview.
No, I did not tell her before the interview.
Ma'am, why didn't you tell her before the interview?
Your Honor, I'm going to object as to asked and answered.
Overruled.
So I have to read her Miranda warnings, and that's what I did. I do not have to tell her that she is under arrest at that time.
Was there a reason, could you have told her that she was under arrest before reading her Miranda warning?
Your Honor, I'm going to object as to calls for speculation.
Sustained.
Ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people such as Ms. Boone, let me specifically. In the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
I confer, Judge.
Yes, sir.
Thank you, ma'am. I have no further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released? State.
We have her subject to recall.
Okay.
Subject to recall.
All right, ma'am, you're released subject to recall. Thank you.
Great, thank you.
All right, now we're getting to the part where the state rests.
State any other witnesses, evidence, or testimony to be produced.
Your Honor, at this time, the state would rest.
Okay. Members of the jury, it is
All right, so now we're going to scooch on to the actual good stuffs.
that he wants to call you first. A prima facie show.
That she has made in regards to what happened on the
Me.
25th.
Put it back on
We see
1
that there are
point
two
or on
distinctly
regular,
different
normal,
sets of
not
statements that were
1.25.
made. So this is sufficient at this stage in time.
Thank you. The court finds that the state continues motion for a judgment of acquittal. I have a couple of
Has always been to put on the defendant last, call whatever witnesses, put on the photographs, and then the client would be the last person to testify. Because of the nature of discharge and our defense, self-defense and battered spouse, we understand that we have to put on her first, Sarah first, as a court to then consider whether or not we established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on and based on that denial of that motion for judgment of acquittal. To just go through it again because I know you're going to ask the colloquy about all that. So I'm going to need a few moments with her. I don't know, it's 10 minutes maybe for the 3 lawyers, 4 lawyers to meet with her. I don't know if we can do it here or maybe back there, but just.
Ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first, without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Approximately 10 minutes. Thank you.
All right, so he gives her a 10-minute break. We're going to skip through that. Blah, 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 blah. All right, you guys.
We're back on the record. Case number
Pretty much
2020
in live time. We're
2603.
like 2
State of
minutes
Florida
behind,
versus
so.
Sarah Boone. State appearances for the record.
Dave Kester on behalf of the state, William J. for the state.
Defense?
Hey, Henny, welcome.
Ms. Boone?
Tony Henderson for Sarah Boone.
Yes, Miss
Ms.
King.
Boone is
That was
seated
a
at
while
counsel's
ago,
table
yeah.
wearing the same black blazer and dark blue
They always
blouse
have- they always
from
do
this
that.
morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters, and if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can
Oh
make
my
most
God,
of the
right,
decisions
Gail?
about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final
Hey,
decision
Ween,
is yours?
baby.
Do you understand that you have the right to remain silent?
Good to see you, girl.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent? That means once you begin to answer questions,
That's funny,
you
Ro.
have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony. Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering an affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarifications, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay, all right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior instances of
Oh my God, I'm out of coffee.
ancillary things that come with self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about it.
Okay, then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is, I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at that.
She getting ready to tell a whole story.
The state had filed that motion for the in-camera hearing. I don't know, maybe we need to hear that before she testifies.
Court's not going to address that at this time.
Okay.
We'll address that
She
later
gonna ask for a
in the
Pop-Tart.
proceedings.
So the two things, number one, of course, I've got
Hey,
a lot of
Spins. Is
photographs
Spins? Did
about
Spins pop it?
prior
There she is. Hey, Spins.
violence that Jorge Torres committed on Sarah Boone, and there is a dispute about whether or not I have to establish
Yes,
an overt
Margaret.
act that she responded to, that she considered an imminent threat, and that she took evidence, or she took action to either block or physically restrain Jorge Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those
And to
statements
Dr.
by
Pepper.
the two detectives. If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures, they were going to see videotapes of evidence that Jorge Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about George. She was trying to protect George, but then she realized she would have to disclose some of the acts that had been committed on her by Jorge Torres, and so she did talk about him coming at me, and we've had issues before, and the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts, or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video, and so I think I can talk about the prior bad acts before the event in question chronologically, and I've got a bunch of photographs.
Oh, no worries,
that,
Spins.
go into
Work and lurk, man.
physical
Work and lurk.
evidence of her injuries as a result of George's George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, as we're trying to get some guidance on this, reviewed Ms. Boone's most recent statements on the matter, and there is no overt act thus testified to. So we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020, before we go into reputation evidence, prior instances of violence, or matters of syndrome evidence.
Any other further argument, Mr. Owens? All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct, which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it before she testifies.
Any response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench.
Right.
These photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence.
Any particular reason why it hasn't been done in the last 45 minutes?
Because
When I sent my jury out?
I've been meeting with my client about
Okay.
her rights to testify or not, and other related matters. So
You have other attorneys
in
that could
terms
do
of
it.
not giving her this evidence,
In terms of anything that the state just discussed?
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase which have been entered into evidence?
I would think 15 minutes.
God.
I'm very concerned because it is 11:25 and I discharged our jury some time ago, and I don't want to be in a position where we have to break in the middle of testimony.
May I suggest that we just take an early lunch? It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5,
What in the name of God?
witnesses that are here, and then I believe tomorrow is Wednesday. We've got Dr. Brannon that's going to be here first thing Wednesday morning, and then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies. And I have not had a chance to view that evidence other than seeing it here today. But I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment?
Right, Gail? If it ends before 5, what? No way she's going to take that long to testify. It spins, ma'am. Have you met Sarah Boone? She can talk forever and ever and ever. You guys, we're in real time. We're in real time now. We are not behind. We were behind just a couple seconds, couple minutes. Now we're in real time. She still ain't on the stand. They are dragging their feet. Dragging their feet. Lord have mercy. Lord, 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 Lord have mercy. Got a gallery full of people. Oh, there's Jules. We saw Jules. They're going to have to figure out what in the world they're going to do because now I need a cup of coffee. I do. Hey, India. Spin says you're right. I retract my statement. Now, Henny, he's not happy at all. He's like, I'm very concerned. Very concerned. I want to know why they want to take a look at the zipper in the back. She's going to be like, see, this is how it worked that night. And what are you going to use the ball bat for? What do you mean? What are we going to do with that? So help me. If they go to lunch and she does not take the stand, I will be so mad. I'll be so mad. Right, India? Will she be getting in the suitcase? Margaret says, somebody come over here and make my bed with me still in it and save me some time. The zipper defense, right? Oh, God. Well, that was a pretty big letdown because I thought that she was going to be on the stand by the time we got caught up to real time. She can change her mind spins until the jury comes in. Yep. She's not going to, though. There's no way. She wants to tell her story. She wants to tell her story. What do you think they're going to do? Do you think they're going to take a lunch break and then have her come on the stand after lunch? Exactly, Rogue. Her story, not the truth. Yes. Her story, which is not the truth. 15 minutes of fame. More like 15 hours of fame is how it's going to be. He's talking about the suitcase and the baseball bat. Something to do with the zipper on it getting stuck and not zipping all the way. And then the wooden baseball bat. Yep. Miss King says, yeah, I think they're going to go to lunch before. No, they're not new. No. He's just saying he wants to take a look at them with her. So, they can maneuver the zipper so she can, during her storytelling, can say, the zipper did this and that. And I don't know. I think it's kind of not a good idea to let her manhandle the suitcase, to be honest. I mean, it's not a dumb
It
question.
is
Spins?
11:35.
No, ma'am, not
Councils
dumb.
have matters that they need to address with Madam Clerk for the pre-marking of exhibits, along with the review of the suitcase and bat, which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
No, sir.
Same question, Mr. Owens. All right, let's go ahead and stand by, bring back in our panel.
Yep, they're going to lunch, folks. They're going to lunch. I'm so aggravated. This is well, man. Seriously? Not happy. Not happy. The judge ain't happy. He's like, rawr.
Jury entering.
I keep trying to text Boone, and it keeps auto-correcting to boobs.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our
Oh,
jury? Thank you. All
God.
can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers.
Yeah, she was
Jurors
hitting.
must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.
Jury exited.
Y'all may be seated. Thank you. State and the defense, if you could please review those items, and please mark every defense exhibit at this time with Madam Clerk, and I will see you all to commence promptly at 1 p.m. Court's in recess. Thank you.
Okay, folks, so here's what's going to happen. I'm going to end this stream, and then I will spark up another stream at 1 p.m. Eastern. It's about an hour and 20 minutes from now. And then I can take care of the other trial that I have going on. Because, an hour and 20 minutes is an hour and 20 minutes. So I'll just be prepared to start another stream at 1 p.m. Eastern. Okay? Maybe like 12. Well, I'll say 1. Just in case they're a couple minutes late. But anyway, make sure to hit the thumbs up button before you leave for this one, for part 1. I'm going to have to rename it part 1. And then I'll see you back for Sarah Boone on part 2 at 1 o'clock. All right. If you are still wanting to hang out for trial stuff, you can come on over to the other stream that we have on the channel currently streaming, which is the Ferris trial. So we'll be over there. All right. We'll see you guys at 1 o'clock. Bye.